LeBron James sued over second decision. In a stunning development that has gripped the sports world, NBA superstar LeBron James is now facing a multi-million-dollar lawsuit over his highly publicized second decision announcement. What began as a marketing spectacle watched by millions has transformed into a legal saga involving contracts, media rights, and allegations of deception within the entertainment industry. The lawsuit, reportedly filed in a Los Angeles county court earlier this week, names LeBron James, his media company SpringHill Entertainment, and several associated business partners as defendants. The plaintiffs, believed to be a small production company and a marketing group that initially collaborated on the second decision concept, allege that LeBron's team breached multiple contractual agreements tied to the production, promotion, and distribution of the event. According to official documents obtained by several outlets, the plaintiffs claim they were instrumental in developing the initial concept of the second decision, envisioning it as a dramatic documentary-style special that would explore LeBron's career, legacy, and potential retirement. However, they allege that once the project gained traction, LeBron's camp took control of the idea, cut them out of the deal, and used similar materials and production outlines without honoring agreed-upon compensation or credit. The lawsuit seeks damages reportedly exceeding $25 million, citing breach of contract, unjust enrichment, and misappropriation of creative material. Attorneys for the plaintiffs argue that LeBron's marketing team and sponsors profited immensely from global attention generated by the event, attention the plaintiffs claim they helped cultivate. When the second decision aired earlier this year, fans across the world tuned in, believing LeBron was about to make a major life-changing announcement. Rumors swirled for days that he might retire, switch teams, or take an unprecedented new role in basketball. Instead, the event turned out to be a promotional launch for LeBron's latest business venture, a beverage brand partnership under his SpringHill umbrella. The revelation sparked mixed reactions, admiration from business leaders impressed by the marketing genius, and backlash from fans who felt misled. Now that controversy has deepened, the legal filing outlines a complex timeline of meetings, proposals, and emails between the plaintiffs and LeBron's representatives dating back over a year. The plaintiffs allege that they presented creative materials, marketing plans, and even the title The Second Decision during early development stages, long before LeBron's official announcement. The document further claims that once the idea gained corporate sponsorship interest, LeBron's team abruptly ended communication with the original partners and went forward with their own production. The plaintiffs now insist they were excluded from financial returns and stripped of creative acknowledgement. Meanwhile, representatives for LeBron James have strongly denied all allegations. A spokesperson for SpringHill Entertainment issued a brief statement calling the lawsuit an opportunistic attempt to exploit a successful global campaign built entirely by our internal team. They emphasized that LeBron and his company have always operated within legal and ethical standards and accused the plaintiffs of fabricating connections for publicity. Despite these assurances, the story continues to evolve. Legal experts across sports media have started weighing in on the potential ramifications of the case. Entertainment attorney Marcus Jennings told reporters, "This case will test the fine line between creative contribution and contractual obligation. If the plaintiffs can prove they originated core elements of the concept, LeBron's team may face serious financial exposure." Jennings also noted that, in Hollywood and sports marketing, disputes over idea ownership are notoriously difficult to prove. Unless written agreements or signed contracts explicitly state terms, claims of creative theft often fail in court. However, if documentation exists showing direct use of the plaintiff's proposals, the case could proceed to trial, a scenario that would bring heavy media attention. Inside NBA circles, the lawsuit has become the latest talking point in discussions about player empowerment and celebrity branding. LeBron James has long been seen as a pioneer in athlete entrepreneurship, building a billion-dollar empire that spans entertainment, sports media, and product endorsements. The second decision was meant to symbolize LeBron's evolution from athlete to global mogul. But now, it's becoming a symbol of how complicated that evolution can be. Sources close to the Lakers forward say he's frustrated by the distraction as the team prepares for a critical season. LeBron, entering his 23rd year in the NBA, remains focused on bringing another championship to Los Angeles while mentoring younger teammates and potentially sharing the court with his son, Bronny James. Yet the timing of this lawsuit threatens to divert attention from basketball to courtroom drama. Sports business analysts point out that this situation highlights the growing intersection between athlete influence and entertainment law. Over the past decade, stars like LeBron, Kevin Durant, and Stephen Curry have expanded their brands beyond basketball, launching media companies, investment firms, and social impact projects. With that expansion, however, comes greater legal exposure. Another layer of intrigue comes from the public's perception of the second decision. When LeBron teased the event on social media, the cryptic tone triggered mass speculation. Fans and journalists drew parallels to his original 2010 decision broadcast, a moment that changed sports media forever. Back then, LeBron's announcement that he was taking his talents to South Beach drew record viewership and unprecedented criticism. This time, he leveraged that nostalgia to draw attention to his business, but it may have crossed a line for some of his collaborators. Reports suggest that several brands tied to the campaign are closely monitoring the lawsuit's progress. Corporate sponsors are particularly concerned about potential reputational damage if the case escalates. One unnamed marketing executive told ESPN that any hint of impropriety around a global campaign like this can ripple through every associated brand. Meanwhile, online reactions remain divided. Supporters of LeBron argue that he's once again being unfairly targeted because of his success and influence. They praise him for redefining athlete branding and controlling his narrative in a media landscape often dominated by corporations. Critics, however, argue that this lawsuit exposes the dangers of overcommercialization, suggesting that LeBron's marketing approach blurred the lines between authenticity and manipulation. Social media platforms like X, formerly Twitter, and Instagram have been flooded with debates under hashtags such as #TheSecondDecision, #LeBron Lawsuit, and #SpringHill Controversy. Influencers and analysts have even begun speculating whether the controversy could affect LeBron's long-term business relationships. Financially, experts estimate that if the plaintiffs succeed, the damages could climb beyond the stated $25 million, depending on lost revenue calculations, brand impact, and punitive awards. However, industry insiders believe a private settlement is far more likely. These kinds of disputes rarely go to trial, said entertainment consultant Lisa Tran. Both sides have too much to lose, in reputation, in brand equity, and in public perception. Behind the scenes, LeBron's legal team is reportedly assembling a robust defense, emphasizing documentation that shows SpringHill Entertainment developed the campaign internally. If those records hold up, the plaintiffs may face an uphill battle. As the legal proceedings progress, court documents will likely shed light on how modern sports media campaigns are conceived and executed. The case could even set a precedent for future collaborations between athletes and creative firms, defining where idea inspiration ends and intellectual property theft begins. Despite the legal turmoil, LeBron continues to maintain a composed public image. During a recent team event, he was seen interacting with teammates, smiling, and avoiding any discussion of the lawsuit. Sources close to him suggest he intends to let his lawyers handle the matter quietly while he keeps his focus on the upcoming NBA season. Still, the story's impact is undeniable. It reignites the conversation about celebrity accountability in business ventures and the growing legal scrutiny surrounding influencer marketing. It also raises broader questions. How much control should athletes have over their personal narratives? And when does a marketing stunt cross into unethical territory? For LeBron James, the second decision was supposed to be another masterclass in brand management, a symbol of evolution, creativity, and control. Instead, it's become a cautionary tale about the complexities of fame, business, and intellectual property. As of now, court hearings are expected to begin later this month. Both parties have reportedly been encouraged to seek mediation before trial proceedings intensify. Whether this case fades quietly into settlement or explodes into a high-profile courtroom showdown remains to be seen. But one thing is certain: the eyes of the sports world, the business world, and the legal world are all fixed squarely on LeBron James once again. And just like the first decision, the entire world is watching to see how this story ends.